Dear viewers, recently we had done a video on all the points you need to know before you buy your property. This episode was specifically for the NRI community. In this episode, we are going to talk to you about all the things that you need to know about selling properties in India. What are the things that you have to keep in mind and every aspect of it. To talk to you about this particular issue, we again have the distinguished faculty, Mr. D B Mehta, in our studio. This is Dr. Chandrakant Bhatt for you in NRI Money Clinic. I am investment consultant and a financial planner.
NRI Money Clinic. No hype, just the right advice.
Dear viewers, we have the distinguished faculty Mr. D B Mehta with us. He is not new to you. He has already come on our channels multiple number of times earlier. We will be giving all the links to the previous episodes here in the card section. Please make sure you watch all the videos we have done with him. It's a treasure of knowledge. He has spoken about buying property. He has spoken about all the things that you need to know about the RERA laws. In today's episode, Mr. D B Mehta will be talking to you about selling of properties by NRIs in India. Welcome to this show, Mr. D B Mehta.
Thank you.
I would like to ask a first question to you. Selling of properties by NRIs, is the process same as that of a resident Indians, or does it differ in any manner?
See, selling of properties by NRIs, there are tax implications and there are repatriation issues. So, right now let us concentrate on the tax implications first. When you are selling a property, the buyer can be a resident Indian or the buyer can also be an NRI.
Okay.
Now, if the buyer is a resident Indian, he has to deduct TDS at the rate of tax applicable to you, and he has to understand whether your sale is a long-term capital gains sale or it's a short-term capital gains sale. Based on that, he can determine the rate of TDS, that is tax deducted at source, which he has to deduct and pay to the income tax department. So, you have to provide the documents to the buyer. So, the buyer can consult his experts or chartered accountant, and he has to determine whether the long term capital gains will be applicable or the short term capital gains will be applicable. The tax rate can be pretty high depending on the value of the sale consideration of your property. So, it is governed by the slab rates of the income tax. Now, if your property value is below 50 lakhs and if it is a short term capital gains, it will be 30%.
Okay.
And above 50 lakhs to 1 crore, there is a surcharge of 10%. Above 1 crore to 2 crores, there is a surcharge of 15%. Above 2 crores up to 5 crores, there is a surcharge of 25%. And if the value of property is above 5 crores, there is a surcharge of 37%.
Okay.
On top of the surcharge, there is an education cess of 4%, which is applicable irrespective of the level of the sale price. So, it is a complicated calculation. Calculation can be very high, but there is an alternate option given to the seller under the Income Tax Act. You can approach the income tax assessing officer through your chartered accountant and ask the income tax department to determine the exact tax liability on the sale which you are going to carry out. The income tax department, you will have to provide all the documents like your purchase documents, the cost, the payment details and the expected sale price along with the agreement that this is the price at which you are going to sell. Based on this data available, the assessing officer will determine the exact tax liability which will be incurred by you. And based on that certificate, the buyer will be happy to deduct the exact amount.
Okay.
Rather than deducting such a high amount.
Both sides are safe in that.
Both sides are safe, and the buyer also knows that he has deducted the correct amount.
Okay.
Because if the buyer does not deduct the correct amount, tomorrow income tax will issue a notice to the buyer for short deduction of TDS with interest and penalty. So, even the buyer can be liable to further taxes if he has not understood or if his consultant has not given him the correct tax deduction amount.
Okay. You said it's a 30% TDS in case if it is a short term capital gains tax. how much will be the TDS applicable for the long term capital
Now,
gains
in
tax?
case if it's a long term capital gains, any property which you have held for more than 2 years under the Indian income tax is considered as long term capital gains.
Okay.
Then the tax per se is 20%. Surcharges, as I have explained earlier, are applicable. Education cess is also applicable.
Okay. Now, when we talk about the TDS, TDS is not the tax, but the actual taxation, does it have any indexation benefit with respect to capital gains tax, long term capital gains tax, like in case of these debt funds or the mutual funds? Are there any such benefits in the real estate as well?
Yeah, there are benefits. So, what happens is TDS is only the tax deducted at source, but you have to file your income tax returns if the sale, if the capital gains short term or long term exceeds the minimum taxable income in India, which is nothing but just 5 lakhs.
Okay.
So, you will have to file your return for that particular year. You will have to show your taxes, and if correct TDS is deducted, you have to claim the credit of TDS. If excess TDS is deducted, you will have to file along with your return of income a claim for refund.
Okay.
And by the time the refund comes and the TDS is deducted, presume a time span of 2 years.
Okay.
So, better to take the necessary step of approaching the department in advance, getting the exact tax certificate, so that the right amount of tax is deducted by the purchaser.
Yeah. My question is, do they get the indexation benefit on the long term capital gains tax?
Now, there is an indexation benefit based on your date of purchase. So, like if your purchase is 10 years back, then there is an indexation chart for each and every year, and based on that chart you can your actual purchase cost will get enhanced.
Okay.
Your purchase cost will get increased.
Okay.
With the indexation benefit,
Which means your profits gets
your notional taxable profit gets reduced and your tax liability consequently gets reduced.
Okay.
And if it's a very old property which you have purchased prior to say the year 2000,
okay,
where your purchase price may be very small, then your indexation will not be based starting from your purchase price, but the fair market value as it existed on 1st of April 2000. And on that fair market value, indexation will be given. So, that way your tax liability will be even reduced further.
Okay. So, if the property was purchased long back, so you will not get into the purchase value of that day, rather on the 1st of April 2000, whatever is the fair market value announced by the government, that is taken as your purchase value. From there onwards, the indexation will apply, and based on today's sale price, whatever is your profits on that, you have to pay the long term capital gains tax.
That's right.
Correct?
Yeah, that's well understood.
My next question is, if an NRI sells this property, is he free to repatriate this money? If he has to repatriate this money, what is the process that he has to follow?
See, the first thing that has to be seen here is whether the property which is selling was purchased by him from NRE or NRO account, that is through the inward remittances, or whether it was purchased by him from his local Indian saving bank account, or it can be even an inherited property from his parents. So, if it is not purchased from the inward remittance, then he can only take the money out under the liberal remittance scheme up to $2,50,000 per annum.
Okay.
So, if he has received more than that value, he has to keep the money in the NRO account. He can only take the $2.5 lakhs per annum and repatriate it.
So, every year he can send 2,50,000 until he exhausts all his sale proceeds being repatriated back.
But if he has bought the property from his inward remittances, that is by sending the amount from abroad, and then he can repatriate up to $1 million without RBI permission, and if he is, and that is again per annum. And if he wants to remit more than $1 million for that particular year, he has to take RBI permission.
Okay. So, it means to say, whenever an NRI buys property, it is very obligatory for them to maintain proper records of from where they have made the payment, you will buy property today and you will forget, and at distant future you will try to sell, and taxation will come and haunt you. To avoid that, make sure that you maintain all the records of from where the payments were made, the bank statements, the images of the check, and all the transactions. These will come very, very handy at the time of determining the tax or in repatriating the amount.
And one small procedure they have to follow, that is, there are two forms which have to be given to the income tax department. One is form 15CA, which NRI himself can fill it up, is simple data.
Okay.
And another is form 15CB, which a chartered accountant has to fill up, showing that necessary TDS has been paid, necessary taxes have been, income tax return has been filed. Those two forms most NRIs forget to file.
Oh, okay.
Because once the money is received, once the repatriation happens, they just forget.
Okay.
So better to file, so that you are not liable for any penalties or any other problems.
So even everything being correct, but make sure that you file both 15C and 15B forms.
15CA and 15CB.
15CA and 15CB forms, to be sure that everything is in order and the department is properly notified and there is no more penalties or serving notice on.
Because why this is important is, say tomorrow you are repatriating some other money from your Indian accounts back to the place of the country of your resident. Say you have received money from your parents or from some gift you have received and you want to repatriate. Then these forms will give a clear cut indication that you have not repatriated the first money under the liberal remittance scheme.
Okay.
So then to repatriate this new amount which you have received, you are having an additional scope of $2.5 lakh.
Okay.
So that advantage you can get.
Okay, fine. Again, there's one another question that is in the minds of NRIs. Let's say that a person from an agricultural community, he goes abroad, becomes an NRI, and he has the agricultural land. Can he sell this land and repatriate this money? Are there any restrictions for them?
See, as an NRI or as a OCI person, you are not allowed to buy agriculture land or a farmhouse or a plantation from your foreign inward remittance.
Okay.
But you can definitely inherit agriculture land, or you can even receive a gift of an agriculture land from a relation.
Okay.
Both these activities are permitted. You are thereafter even allowed to sell the agriculture land.
Okay.
But because your investment is not through foreign inward remittance, you will be only allowed to take under the liberalized remittance scheme of repatriation of $2.5 lakh per annum.
Okay. So there is no question of buying any of these things from the remittances that you have sent from abroad.
No way.
Okay, fine. One another problem that faces NRIs is, many of these NRIs have sizable ancestral property. They have migrated to one part of the world. They have no intention to come back. Parents have left this world. They are left with huge real estate back home in India. How can they dispose of these ancestral properties? Are there any specific processes, clearances to be obtained, and is there any other tax obligations other than that we have already described in this episode?
There are no specific clearances required.
Okay.
Like any other property, you can sell this property, provided your documentation with regards to the land or title are all up to date. So those issues you will have to take care of through property lawyer who practices in the civil courts or who practices for property matters, and to see that all your documents are up to date, because no buyer will buy any property if the documents are not up to date. So that is the first step you have to take. The second step is, again, when you are selling, the buyer has to deduct TDS, because the property has been inherited, but your status as on the date of selling is an NRI. So
yes,
he has to deduct the TDS as it is applicable to the NRI. And you are again liable for the income tax the same way as we have discussed in the earlier question. So those precautions, those formalities you have to take care of. Now for remittances, again, you can be remitting only $2.5 lakh under the liberalized remittance scheme, because this property has been inherited and not bought from your foreign inward remittance.
So it is governed by the other rules, leveraged remittance
Yeah.
scheme. So it will not come under that $1 million for NRIs. They can't just take it out from the sale of ancestral property.
And if it's an inherited property, you can always gift part of the property to other family members' name, because in India there is no gift tax for gift within the family members.
Okay.
The stamp duty varies in different states, but in Karnataka it is only 1000 rupees if it is gifted within the family members. Then each family member after sale of the property is entitled to take $2.5 lakh out in that year.
Okay.
So, suppose your property sale price is around $10 lakh.
Okay.
So, instead of owning it in one person, see that you gift 25% in 3 other names, get those gift deeds executed, get them registered. Stamp duty liability is just 1000 per document.
Okay.
There is no income tax liability because it is gift within the family.
Okay.
But then after that, when you sell, now there are 4 sellers rather than 1 seller.
Okay.
So each seller is allowed to take $2.5 lakh and he can repatriate it.
Okay. So that's a
Yeah.
we call it as a loophole or a system or something that you can do to quickly repatriate your money,
Your money.
within the scope of what law provides for you.
Yeah, that's right.
There's one another important issue when it comes to the question of selling of properties by NRIs. Now, resident Indians have a chance to save on the capital gains tax by investing in some of the capital gains saving tax bonds and other things. What are the facilities which are available for NRIs to save on this long-term capital gains tax? Can you just elaborate on this particular topic?
See, under the Income Tax Act, basically there are 3 sections which are applicable to save tax on only long-term capital gains. Let me be very clear, I repeat, long-term capital gains only these benefits are available.
With respect to real estate?
With respect to real estate, it can be houses, it can be a developed plot, or even it can be a commercial property.
Okay.
Okay. Now, under section 54, the capital gains, if it's a sale of a house, it will come under section 54. If it's a sale of a plot or if it's a sale of a commercial, it will go under section 54F. Both the treatments are different. Under section 54, you have to only invest to the extent of capital gains determined.
Okay.
After indexation cost and everything.
Okay.
Whatever is your capital gains, only that much amount. If you buy a new house,
Okay.
then your tax liability is 0.
Okay.
The department has put one more condition there, that you should not be owning more than one house at that point in time.
Ah.
So it is only 1+1 scheme. If you have one house, you can buy one more house
Okay.
and save the tax completely by investing only the capital gains, not the sale proceeds.
Okay.
Okay. The second section is under section 54F, where irrespective of what type of property you are selling, you may have more than one house and you are selling a residential house, or you are selling a developed plot, or you are selling a commercial premises, but all are eligible for long term benefits. Then you have to invest sale proceeds in a new house and you will be exempt from tax.
Not just the capital
No,
gains,
entire
proceeds have to go.
Proceeds have to go.
Okay.
Then there is one more section that is called 54EC. In that there is a very limited benefit. Up to 50 lakhs you can invest in specified government bonds. Now these are specified capital gains bonds,
Okay.
where normal interest rate is around 4 to 5%. Interest is taxable, lock-in period is 5 years. Up to 50 lakhs if you invest in these bonds, then that 50 lakhs will be exempt from your capital gains.
But the limitation is 50 lakhs.
50 lakhs.
Okay. These are the 3 provisions which are there, which can help you reduce the tax
Tax
impact.
liability.
Thank you very much, Mr. Mehta, to bring all these points for the benefit of our viewers. It's not as simple as it looks. There are a lot of things which people need to be knowing before they sell the property. Hope this episode is of great value to you, and it has given a lot of insights into preparations that you have to make before selling the property, the tax impacts and other things as well. Thank you, Mr. Mehta, for bringing all this to the benefit of our viewers.
Thank you.
Dear viewers, the episode that we have done today, if it has added value to you, if it has given knowledge about selling the properties, the taxation and various other subjects, please like this video. If you are a person who is watching this channel for the first time, or if you are yet to subscribe for this channel, make sure you hit the subscribe button and press the bell icon. Don't forget to share this video with your friends and relatives. Thank you very much for watching this episode on NRI Money Clinic. I will be back with you with yet another topic in yet another video very soon.